This is Report to Wyoming.
This show targets local issues that matter right here in Natrona County, where we talk to real people about their thoughts and ideas. 2 episodes ago, at the tail end of July, I sat down with the local assessor Matt Keating and later Dallas Laird to talk about the issue of rising property taxes. You can listen to those on the on-demand app if you're interested. That episode prompted an attorney named Tom Green to reach out to talk more about the topic and his experience trying to appeal a tax assessment. For most of 2021, Tom Green served as a deputy county attorney under Eric Nelson. Green said he resigned in disgust over the proceedings in his appeals case from that year, which he argued on his own behalf while working in the same office as deputy county attorney. It's a long story, so I asked Tom to just take us to the beginning.
Well, the fact that I was a deputy county attorney here in Casper last year at this time, during the big hit of all the tax appeals that were going on, and I actually had one myself because I owned a piece of property up on Garden Creek Road with 2 other people, and we bought it for the purpose of having it as a buffer zone between our residences and the Garden Creek Road there, and so that went along for quite a while, and we decided, well, the 3 of us own this, and we're tenants in common. We better do something with this property to make sure it's tied up forever and controlled, and nothing can be ever developed on it, and it can never be sold, and all those factors. So they had me, since I was an attorney. One was Pete Greiner, who is owned Ford at that time. The other one was Dr. Scott Benyon, who's a dermatologist in town.
Can you pull your microphone a little closer?
Sure.
All right. Perfect.
Okay, so one was Scott Benyon, one Pete Grinders. There were 3 families basically bought a 1-acre lot as just a buffer area. So we decided to record CC&Rs, covenants, conditions, and restrictions against the property to make sure it could never be sold except a person could sell his interest in that property along with his residence. When he sold his house there, that would go with it. But he couldn't otherwise ever sell it separately for any purpose. Number 2, it couldn't be used for anything, no vehicles on it, couldn't do anything to mar the landscaping or the vegetation. It just could only be used for normal recreational picnic purposes, walking, anything like that. No development could ever occur on it, no buildings, no nothing. And also it was all of our wells for our own properties were up front right next to this adjacent property. So we didn't want anything to interfere with our wells. So that's another reason we bought it, and we wanted it restricted so that nothing could ever be developed. So we filed those CC&Rs. And then as soon as Matt Keating took over the assessor's office, that's when everybody that owned vacant land really got hit pretty hard with doubled the previous taxes from the previous year and things like that. So they asked me just to check into that and see if that was correct or maybe appeal that higher tax assessment. Well, I was already, by that time, we owned the property before I became a deputy county attorney, but now by the time it's time for this tax appeal, I was a deputy county attorney. So I just told Eric Nelson, the county attorney, that, I have my own tax appeal, by the way. I don't know how that's going to work out here. We'll have to do something because of the conflict of interest. We'll have to take some precautions. I just want you to know that. But I haven't filed any appeal yet. And, I'd just like to talk to him down there, to Matt Keating and everybody. And I already have started those discussions. And I said, so just keep that in mind. He said, that's no problem. You have a right. You're a citizen, too. You have a right to a tax appeal. So we'll just go with it as it comes. I said, yeah, no problem. So that's how it all started. But once then it slowly started developing. I got no response from the assessor's office, like 0. They just shut me out and wouldn't give me any information. And I didn't know, and I emailed them. I have copies of the email and everything about, I said, has a block wall been put up between us or something? Or have you been told not to talk to me? Or I said, whatever, it's fine. I just like to know what's going on. And went on and on and on, and nothing. So they took me right down. Finally, Corey Cabral from the assessor's office gave me her final email and said, we're right up against your deadline for filing an appeal, and I can't get back to you before then, so just go ahead and file your appeal, and we'll just go that route. And I go, okay. So I filed my appeal. Then as soon as I did, then a wall kind of went up in my own office because the deputy county attorney that handles those matters, Charmaine Reed, I didn't realize it. She got very upset that I was filing a tax appeal and that she would have to work on it. And she even a little bit later confronted me about that and said, "Are you really going to waste my time on this? Waste all the time of the county commissioners on this frivolous appeal?" And I go, "Whoa." I just go, "Yes." And things went from bad to worse. It got so bad that she finally responded to everything I'd been inquiring about to the assessor's office. She, in a letter that was hand delivered to me in the office, it's like formal service, and it contained false misrepresentations of the facts and the law, and so that really I did not like that at all. That was like, that's crossing the line. And so when that happened, I just quit. I just resigned from the county attorney's office. And I just told Eric, I said, I can't work in the same building with her, let alone the same adjacent offices. So I'm out of here. He says, I understand. And so he says, and so because I left, we were trying to figure out that conflict of interest issue. He even thought for a while he should get outside counsel to handle my appeal, and that's crazy. All that expense just to deal with my appeal when we could resolve this just by talking, and so he told me as a result of that he took Charmaine Reed off the case and he decided to handle it himself. By that time, we were right up against deadlines and everything, so I filed a motion to compel the discovery and to compel the information that I was requesting, and he responded to that. And I was very interested in that to see how he would respond, because it was clear that she was misrepresenting the law in her letter to me. He picked up the same ball and ran with it. He misrepresented the law and did exactly the same thing. So that was it as far as I was concerned. But I really thought at that time it was just me. I thought, this is just because of it's me in this situation, and I've put them in a big jam because of this, and I haven't looked at it from their viewpoint. And so I think this treatment that I'm getting and no information being provided, withholding information that I'm statutorily entitled to receive, concealing information, refusing to produce it when they have to, when they know that I have a deadline to meet to set it forward about what information and exhibits I'm going to use at my hearing, knowing all that, they were withholding information and refusing normal, legally mandated discovery. So, but I just thought I'm probably the only one that this is happening to, and it's because of the situation. So I just have to do the best that I can. So I still thought there was a good side to Eric Nelson, and that I could basically talk with him and try to work things out. And he drove me until just before the hearing, when he finally agreed to talk to me, and then he caved in on it. He was very smart the way he played this. And instead of going through the motion that I had all lined up with court, 100% properly brought before the court and ready to go, and I had him by the neck. He had no place to go. They had failed to respond, everything. They missed deadlines to respond. I had him solid cold. I didn't want him. I didn't want to do something like that. I want to get along with these people and just try to resolve this amicably. So I talked to him about it, and he says, well, what do you really want? And I said, well, in the meantime, I could see where this was going. I wasn't going to get any information, so I just started pursuing it by myself to dig out information. I got on the assessor's website, got on their mapping application, and I found the similarly situated properties that I was looking for, other properties that are restricted by CC&Rs and can't be sold and can't be developed and everything. Those are called intangible characteristics in the tax law that have to be taken into account in assessing values. The intangible characteristics which affect value have to be considered by Supreme Court decision, by statute. So I was looking for other properties that had the same intangible characteristics, restrictions that prohibit building, prohibit sales, and I found about 18 parcels, and I think all of them were associated with homeowners associations. They were open space, set aside as open space in various developments, various subdivisions, and set aside to never be developed, forever be open space, to be maintained by the homeowners association. The property belonged to the homeowners association, and it would be maintained for the benefit, the aesthetic benefit to the surrounding homes. That's exactly why we bought our lot. So I thought that was sufficiently similar that those properties should be used in evaluating our taxes. And I also found out that every single one of those properties, no matter how big, some I think from 8 acres to a half acre, they measured, they're all valued, fair market value, actual value at $500. So every single one, no matter what the size. So obviously what they were saying there was, we're just assigning a nominal value to these properties just to have sufficient information to enter it into our computer. We got to put something down. So they just arbitrarily selected $500. I don't have any idea if that is statewide or not, or where they got that figure. They wouldn't tell me anything about that. So when Eric asked me that question, so what exactly do you want to go into this hearing? Because I had all these demands of information I was requesting. I said, Eric, there's a real simple way to get around this. I already have the properties. I've given you all these maps that I had printed off from your mapping locations showing the properties. They have the assessor's parcel number printed right on them. So I ordered up the property profiles on each one of these, so I know how big they are. I know that it's limited use, and that's how they're categorized. So when you guys represented to me that there was no way to look up these kind of properties in the assessor's system, I said that was a bald-faced lie. It's very easy to look up. I looked them up. I know nothing about your system. I looked them up from the assessor's website. Hello, how hard is it to look up these properties? And they're all valued at $500 each. You're valuing mine as a developable mountain residential property, four lots together. So you're the side-by-side adjacent right on Garden Creek Road. So I said, you're valuing my properties as grandfathered in lots on Casper Mountain Road that are fully developable, buildable upon, and charging me those kind of tax rates, like valuing them at like $100,000 a piece, when you're valuing these at $500 a piece. I go, and you're not taking into account the fact that I have these CC&Rs. And they said, I'll show you Charmaine's letter. What she said, we do not take into account CC&Rs in evaluating a property, when I have 18 parcels where they do take into account the CC&Rs and the restrictions. So, but I still thought I was getting hammered alone. I had no clue that at that time that this was happening to other taxpayers, except that I hired, as an expert witness, when it finally came time to go to the hearing, I hired Cindy Barlow. She's a Wyoming former tax assessor, and she's currently an expert witness in tax matters, and she's used as an expert witness to testify in tax cases. She's been used in Natrona County a lot. The legislature is having her come and testify all the time concerning tax matters in the legislature. She's like highly respected and accepted as like probably the leading person in Wyoming right now that's willing to talk. Nobody else, no ex-county assessors are willing to talk. She is. And she's smart as a whip, and she knows this stuff backwards and forwards. And I ask her, is this common where they're withholding information from taxpayers? She said, I asked her, how many appeals are you involved in right now? And she says, oh, Tom, I got tax appeals all over the state of Wyoming. I said, how many are they withholding information and not providing information to the taxpayer? She says, 100%. This is not just Casper. This is everywhere. And I said, well, how do they get away with that? She said, the taxpayers don't know. Taxpayers don't know what their rights are. They don't know what questions to ask. They just go in and try to get information from the assessor's office. They're not provided with the information. They're just told when their deadline is for their tax appeal. As soon as they file that, then they get a notice of deadlines that they have to comply with.
So for the naive listeners like myself, why are they doing this? Why are they withholding information, and what do they have to gain from that?
Right now, this is the situation I believe is happening. I believe I'm just limiting this to Natrona County. I think the county attorney and the tax assessor are in lockstep, absolutely lockstep, in the same framework, the same frame of mind, and they're doing this. They are withholding information from the taxpayers, not providing information that the taxpayers are entitled to, not providing even the type of transparency that is, you can see this from the statutes I'll provide you, that the system is designed to be really transparent and really taxpayer friendly to obtain information, and it's not. Not only that, then they are together misrepresenting the law to the hearing officer that's hearing these cases and to the county commissioners. The reason they're doing it is because they are so shallow and so into power and position. They're maintaining control. They want to maintain control of this entire tax assessment issue and maintain that power over the taxpayer so that nobody can challenge them. And the average taxpayer, there's no way they can challenge them without an attorney and win. It's like very seldom. The only people that get fair treatment as a single taxpayer going in front of Matt Keating are business people, rich business people or rich residences who he does accommodate, and he will often change their taxes without an attorney or anything. The average taxpayer doesn't have a chance. So it is power. What I'm trying to do right now is to get this word out to as many taxpayers because this is just so wrong. It's also really unethical. I could show you the canons of ethics for attorneys and how one of them is entitled candor toward the tribunal. You cannot misrepresent the status of the law to the tribunal. You cannot withhold discovery and information that an opponent is entitled to receive. Those are violations of the canons of ethics. So this is so serious that I think it should be brought to the county commissioner's attention right now. I think it's possible that the county commissioners don't even know this is happening to them, that they're being led by the nose down a primrose path to defeat taxpayers illegally. And I'm not sure that the commissioners even, they must have a clue, but I don't think they know the extent to which this is happening and how serious it is. They hire and fire the county attorney, so it's pretty much their responsibility to oversee the county attorney, and they are not. So that's the only thing I hold against them, is they, so far, for the last year or plus, have allowed the county attorney to get away with this, and I believe it's because they don't know what's going on. They don't know that they're making misrepresentations of the law and the facts. And to the hearing officer, why hasn't the hearing officers saved us from this situation? I don't think the hearing officer even realizes what's going on. I have no evidence whatsoever to indicate that the county commissioners or the hearing officer are in on this. I have absolute positive proof in writing that the county attorney and the county assessors are in on this together.
Can you describe that for us?
It stems from when you go into a tax appeal, it's up to the taxpayer to request information. So I think the best place to start, in any case, is the appeal that I handled, because that's my appeal. I'm familiar with it. I don't have to front anybody else out on any other appeal. And so and I have permission from my other two owners to totally divulge that information. So I had to go in and do everything correctly according to statute. That's all in writing. I did everything according to statute, according to the rules, and it's provable. And I have the statutes. They're all in writing. The exact law is all perfectly in writing. Now it's important at that point to realize the law here is very complex. You have the Constitution of Wyoming, which has certain provisions, but those aren't overriding in this case. Next important thing is you have statutes. Statutes are what control and what gave the Department of Revenue the ability to make rules, is by the statutes. But the rules have to be formulated in compliance with the statutes. One of them is the Administrative Procedure Act, which has really specific requirements to all administrative agencies, not just the Department of Revenue, but everything else. Also, everybody has to follow the Administrative Procedure Act. And that specifies in there that discovery, the right to obtain information in all administrative hearings shall be governed by the Wyoming Rules of Civil Procedure. Period. Shall be. That means that's it. So, but when they passed their rules, they passed one rule which gave the County Board of Equalization, which is the county commissioners, they gave them the right to, if requested, to also direct discovery. So I think that's just an additional provision that they gave the County Board of Equalization also through these rules the right to direct that discovery be granted. They could be in the middle of a hearing, for example, and realize that certain information is not available. They have the power to direct that information be provided right now. They could continue it till the next day and provide that the assessor demand that he provide that information. He's an independent elected official, so they have no direct control over the county assessor, except by these rules and these statutes. And so they were given that power to direct him, if necessary, to provide discovery. Well, this is how slick the situation is, and I'll show you this when the county attorney responded to my request for information, how they used that rule, stating that the only way you're entitled to get discovery, ignoring all the other rules and the statutes, and just centering in on that one rule where the Board of Equalization, County Board of Equalization, has the right to direct discovery if requested. So they say in their response to the hearing officer, in response to my request for information, well, he never got direction from the Board of Equalization for discovery. He never asked them for it and never received it from them, so he's not entitled to discovery at all. So they take this little rule and tell me this is like brilliant, actually. It's going to fool anybody that doesn't know. It doesn't fool me. They're actually just, if I wish I could say it, full of something. They're full of themselves is what they're full of. And any attorney, I believe sincerely right now that if I talked this over with Mr. Nicolason and showed this what's happening, he would be as appalled as I am, that they are using this trickery and skullduggery to, it's actually a misrepresentation of the law. They're saying that we have to comply with that to get discovery as a taxpayer. No, that's false. That's absolutely false. It is absolutely a misrepresentation of the law. And then we get into the canons of ethics. I could right now file a bar complaint against them for doing this. I have not done that because I want to take it to the Board of County Commissioners. So I want to be very straight with them what I'm doing. Right now we are so close to this election and there are so few alternatives that I myself have decided I absolutely want Dallas Laird elected for a single reason. He's a troublemaker. He's a rabble-rousing troublemaker, And he went before to the city council, to the city, and was elected to the city council. Got himself elected there, and led the revolt to get the city attorney kicked out. That city attorney, and now they have a new city attorney in, and everything is great. So he's been through this exact scenario once before. A absolute incompetent, at least, city attorney, or in this case, county attorney. I want him here for that. I think it's absolutely crucial that Natrona County elect him, just to have him in there as a counterweight against the county attorney. Without some sort of a big counterweight against the county attorney, that county attorney is going to keep running roughshod over everyone, especially taxpayers. That's number one. Number two, I think I'm very afraid of Mr. Nicolason being friends with Matt Keating. And that's a synergistic relationship or something. I don't know. But, and I don't know to what degree Nicolason will be an honest, straight shooter. I'm real anxious to see that and to find that out. In the meantime, I think we have to kick Keating out of there. Absolutely. He has no business being our county assessor. And the only person, that leaves us with Tammy Salisbury. She's the only person with any qualifications at all to be tax assessor right now. But I can virtually guarantee you, if you put those two people in, Tammy Salisbury in as a tax assessor and Dallas Laird as one of the county commissioners, this whole tax assessment issue would be solved. It could be solved in 1 month if you have honest people in there doing the right thing.
Do you know what excuse me, I'm not making much sense, the trial will entail? Is this specific issue going to be on trial?
A great question, actually. Mine is done, of course. So my case, I did not even appeal it, my case, because, and I should tell you this, at my hearing, I lost in front of the county commissioners, and they all voted against me but one, and one abstained, Bartaglio, because he's a really good friend with Matt Keating, and he abstained. But at the end, after it was all over, Commissioner North and Commissioner Bartaglio asked me, I think this was even, I'm not sure if it was when they made their decision or before or after they made their decision, but they said, Tom, why don't you just combine these 4 parcels into one parcel up there and just have it taxed as one parcel? I said, well, very good question. I wish I would have been asked that question by Matt Keating or anybody prior to this hearing. I'll tell you the direct answers because I didn't know anything about it or that you could do that. I had no idea. I said I only appealed the tax because I see because on the legal basis, the CC&Rs were not taken into consideration in evaluating the property. That has to be done. That's why I took that route. I said, I don't know what effect that would have for me to combine all 4 parcels into one parcel. I said, I'll look into it. So I lost that hearing. They voted against me, and I went and looked into that. That went through without a hitch, and I ended up with taxes on that 1 acre parcel lower than before I appealed. So mine came out to the point where I'm not going to go and argue this over nothing. But strangely, I never got a copy of their order or their findings of fact and conclusions of law, which I was entitled to receive. I just found out recently that they did issue one. They just never sent it to me, which is required by law. So from here, when I leave, I'm going directly over there to see the clerk of the commission and see if I can get a copy of that. But I was totally satisfied with the way it turned out. You know, all of the 3 property owners were. So, but my case is a good case because I have it in writing, those misrepresentations that they made. And there's really no legitimate argument that can be made. There's arguments that can be made, for sure. It's a very intelligent scheme that they have going to prevent people from getting discovery by twisting and actually circumventing the law rather than following the law. And lawyers really aren't for that, supposedly. I would think government lawyers, should not be engaged in that.
On Tuesday, August 2nd, Tom Green went to the Natrona County Commission to speak during public comment. Green said he's just one of thousands of property tax protesters who have been shortchanged in the appeals process by misrepresentations of the law and deprivation of evidence. He reinforced all the things he told K2 Radio News in our interview. Of course, this is just one man's side of the story, and I welcome anyone who wants to provide a fresh perspective on the matter to reach out to K2 Radio News. Reporting in Casper, this is Colby Theodore.
This has been Report to Wyoming, presented in the public interest by Town Square Media.